Hello, good morning, Dr. Sasahab.
Good morning. Can you hear me?
Yeah, this is afternoon here in Indonesia.
Good afternoon. Selamat sore.
Yeah.
Good to see you all.
Can you hear us clearly from here now?
I can hear you wonderfully, yes.
I think we'll be start in 2 or 3 minutes.
Okay, no problem. I'm setting up my live show in the meantime.
Hello, Sasa, can you monitor us?
I can hear you. 1 second.
Okay, can we start now?
Yes, I go back to.
Yeah, I think there are introduction from the MC and welcome speech from the Dean.
Okay.
Okay.
Ganti tugas apa bang? Beres uminya lo aku.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah. Alhamdulillah Rabbil Alamin. Arsala rasulahu bil huda wa dinil haq. Liyuzhirahu ala dini kulli. Walau karihal musyrikun walau karihal munafikun. Asyhadu an la ilaha illallah Wa asyhadu anna Muhammadan abduhu wa rasuluhu la nabiyya ba'da. General Dr. Shasha Hart, Assistant Professor of Comparative Constitutional Law at Maastricht University, Netherlands. General, the Deans, Lecturers, and students of Law Faculty of Bengkulu University, Law Faculty of Muhammadiyah University, Yogyakarta, Law Faculty of Muhammadiyah University, Mataram, Law Faculty of Muhammadiyah University, Kota Bumi, Lampung, Law Faculty of Muhammadiyah University of Tangerang, Law Faculty of Muhammadiyah University, Jakarta, and Law Faculty and Family Law Study Program of Muhammadiyah University, West Sumatra. Ladies and gentlemen, a very warm greeting to each and every one of you. Welcome to Yunahar Ilyas Convention Hall for the International Studium General 2023. I'm Susi Susanti, the MC for this event. On behalf of the organizing committee, we extend our appreciation for your presence today. On this special day, deans, lecturers, and students from several universities in Indonesia are gathering with us, hybrid, online, and offline, all with delighted spirit and pride. They are all ready to obtain knowledge about legal education and 21st century. Well, ladies and gentlemen, without further ado, let us start our program by welcoming the Dean of Law Faculty of Muhammadiyah University West Sumatra to deliver his opening remarks. Please welcome Mr. Wendra Yuneldi, SHMH.
Assalamualaikum warahmatullahi wabarakatuh. The Honorable Mr. Dr. Sasha Hart, LLM, Assistant Professor of Comparative Constitutional Law at Maastricht University in Netherlands. We would like to thank him for taking the time and sharing his knowledge with us at this valuable occasion. The Honorable, the Dean, the Head of Department or Study, the lecturer and student from Law Faculty of Bengkulu University, Law Faculty of Muhammadiyah University of Yogyakarta, Law Faculty of Muhammadiyah Universitas of Mataram, Law Faculty of Muhammadiyah University of Kota Bumi, Lampung, Law Faculty of Muhammadiyah University of Tangerang, Law Faculty of Muhammadiyah University of Jakarta, and big family of law faculty include Family Law Study Program of Muhammadiyah University of West Sumatra. All praise to Allah, the one with His love and mercy, we are able to meet and help a joint Studium General about legal education in 21st century between globalization and digitalization, online and offline at Muhammadiyah University of West Sumatra. And now we at host of this event. The challenge of globalization continue to occur, including how legal education adaptive to digitalization, including development of intelligent artificial, so that campus can produce competitive legal scholar in the global world. We are very grateful to our lecturer, Mr. Ferry Kova, LLM. He is the one who linked us with Dr. Sasa, and they are best friend. Even since they were studying master degree at Maastricht University, Netherlands. So that we are able to help public general online today. Hopefully, this activity will end our knowledge and legal education in first century. We are looking forward to see. We are looking forward to see you soon. So on, Dr. Sasa at Muhammadiyah University of West Sumatra in this December. Well, ladies and gentlemen, that all the welcoming speak from me. Thank you for your kind attention. Assalamualaikum warahmatullahi wabarakatuh.
Well, ladies and gentlemen, this is the end of the opening ceremony of the International Studium General 2023. Now, we are going to start our main session on legal education in 21st century between globalization and digitalization. Now, let me hand over the session to the moderator. Please welcome Mr. Ferry Kova. Time is yours.
Thank you, Bu Sesi. Good afternoon, everyone, and good morning to you, Dr. Sasa. So it is morning in Netherlands.
Yes, good morning there. Good afternoon there. Thank you very much for having me.
Thank you. So I am Ferry Kova, a lecturer at the Faculty of Law, University of Muhammadiyah, West Sumatra. Will guide you for this international public lecture series with the themes legal education in 21st century between globalization and digitalization. Baik Bapak Ibu, saya Ferry Kopa, dosen Universitas Muhammadiyah Fakultas Hukum, akan memandu Bapak Ibu hadirin para peserta selama kurang lebih dalam 100 menit ke depan dalam rangka pelaksanaan salah satu seri dari kuliah umum internasional kita yang hari ini akan disampaikan oleh Dr. Sasha Hart selaku keynote speaker. So for the first of all, I will introduce our speaker, Dr. Sasha Hart, LLM. Dr. Sasha Hart adalah asisten profesor perbandingan hukum tata negara dari Maastricht University, Netherlands, dan saat ini juga beliau koordinator program-program kehormatan di Fakultas Hukum Universitas Maastricht, Netherlands. Beliau juga terafiliasi dengan beberapa kegiatan di Indonesia seperti pernah sebagai asisten profesor di Universitas Airlangga, kemudian juga sebagai koordinator proyek dari Orange Knowledge Program yang disebut dengan LEAP, Legal Education, Ethics and Professionalism. Dalam konteks ini ada kurang lebih 6 universitas di Indonesia yang mengikutinya dan bergabung dalam suatu jaringan pendidikan hukum Indonesia yang bisa diakses melalui website www.japi.id, yang mana program atau proyek ini didedikasikan untuk inovasi pendidikan hukum di Indonesia. Beliau juga co-editor dan co-author dari buku Legal Education in 21st Century, Indonesian and International Perspective, terbitan Den Haag 11 2022. Dan beliau juga sangat aktif mengajar dan memberikan pelatihan-pelatihan hukum, pengajaran pendidikan hukum di berbagai universitas di Indonesia, baik secara online ataupun offline. So without much further ado, we welcome our speaker, Dr. Sasha Hart. So Dr. Sasha, the floor is yours now. Kuliah ini juga nanti akan disampaikan oleh Dr. Sasha dalam bahasa Inggris dan saya akan mentranslasikan dalam bahasa Indonesia. Dan kuliah ini juga diikuti oleh mahasiswa secara online dan juga oleh berbagai universitas Muhammadiyah se-Indonesia yang ada, baik Yogyakarta, Kota Bumi, Fakultas Pendidikan Agama Islam Universitas Muhammadiyah Sumatera Barat. Okay, Dr. Sasa, the The floor is yours now.
Thank you very much. Thank you very, very much for the kind introduction, Pak Dekan, and thank you very much. Good to see you again, Pak Ferry. As was explained before, we go back a long while since doing our masters together at Maastricht University, and I'm very, very happy soon again to be back at Muhammadiyah University in Bukit Tinggi. Which is only a couple of weeks ago. So for me, this is a little bit of an entry into my trip to Indonesia, which is going to start soon. I have prepared some slides, so I'm going to start sharing my screen now. I hope that this is visible to you. Can you see my slides? Could you briefly confirm if you see my slides?
Yes, we can see it clearly.
Wonderful. So the topic for the talk this morning is that I've been asked to give is legal education in times of globalization and digitalization, which of course is a topic that concerns all of us, whether we are students, teachers at university, course developers, or other stakeholders. Yesterday, I spoke to a delegation from the Ministry of Education of Indonesia, visiting my university and talking to the ISMA exchangees that we have here, and also their digitalization, globalization, international experiences, how this can be augmented by digital learning, all came up as a topic. So it is really the topic of the moment. Today, I plan to briefly address three dimensions of this topic. Before I do, I would like to clarify that some of the content of the talk that I'm giving this morning is also reflected in some more length and some more breadth in the publication that we were able to bring out last year, this book, Legal Education in the 21st Century, which was already mentioned in the introduction. And I would very much like to invite every one of you, whether you be teachers at universities, teaching staff, course developers, deans, or students, to visit our website, japi.id, Jaringan Pendidikan Hukum Indonesia .id, where also some of the materials that I refer to in the course of my talk are freely available for everyone. And of course, also a warm invitation to all the universities represented today to join this network, which we have been able to create in the course of the LEAP project, which has finished last year. I suggest that when I start the content of the talk, that I always talk for a minute or two and then wait for the translation, but you will see that the slides are bilingual. So I try to make the slides in Bahasa as well.
Baik, Dr. Sasa sudah memperkenalkan, beliau juga sudah bahwa sebab materi dan ini memang berkaitan dengan suatu proyek yang pernah kerjakan bersama dengan beberapa perguruan yang dibiayai oleh Orange Knowledge Program yang disebut dengan LEAP Legal Education. Kemudian proyek ini juga menghasilkan buku Legal Education in the 21st Century, pendidikan hukum di abad 21 dalam perspektif internasional dan Indonesia. Dia juga mengajak kita bersama, baik itu para mahasiswa, para sivitas akademika, para dekan, dosen yang terlibat untuk dapat melalui untuk mengakses web dari Jaringan Pendidikan Hukum Indonesia tersebut, japi.id. Di pengantar dari beliau, perlu juga kami ingatkan kepada para yang hadir pada saat ini secara online juga dapat mengisi daftar hadir melalui link chat oleh panitia untuk sertifikat. Oke, Sasa.
Thank you. So here are the three dimensions that I have been speaking about. And by the way, I must apologize if my translation into Bahasa is not perfect at all times. I hope that it is understandable to you in this way. So the first topic that I would like to address is the question of curricular content. So what is it that we should teach future lawyers, future jurists, and what future generations of legal professionals should learn in the light of these trends towards globalization and digitalization? So I'm first going to see what globalization, digitalization really means, what effects these have, and what this means to the content of our legal teaching. And second, I would briefly like to go over, and of course we don't have time to do this at great length, but in a summary form, go over the teaching and learning methods that are best suited, in my opinion, and also in the practice that we have established over the last couple of years at Maastricht University, but also at many universities in Indonesia, of how to teach these specific curricular contents that I will explain. And then lastly, and this is really something like an add-on. Oh, somebody is drawing in the slide. So lastly, as an add-on, I would briefly like to address the topic of artificial intelligence. Now, there is today no way around artificial intelligence. We are faced with it in legal education as well. We know that students are using it. Some teaching staff are also using it. So the question is, what should we do with it? Should we ban it? Is it dangerous? Is it something that we should keep out of our universities, or are there ways to maybe use it constructively and use it wisely and somehow integrate it in the legal education that we offer? So these are the three topics that I would like to briefly address today.
Jadi ada 3 topik garis besar yang akan disampaikan oleh Dr. Sasahar dalam perkuliahan pada hari ini berkaitan dengan pendidikan hukum di era 21 di antara digitalisasi dan globalisasi. Pertama, ini berkenaan dengan konten atau isi dari kurikulum yang ada di pendidikan hukum, fakultas-fakultas hukum yang ada. Jadi hukum dan konteksnya sekarang sudah semakin mengglobal dan digital ya. Jadi apa yang sebaiknya dan seharusnya dipelajari oleh seorang calon yuris di masa depan. Kemudian juga terkait dengan bagaimana metode pengajaran dan pembelajaran di era globalisasi dan digitalisasi. Kemudian bagaimana peran artificial intelligence atau kecerdasan artifisial dalam pendidikan hukum di abad sekarang yang sebagaimana disampaikan oleh Dr. Sasahar tadi, ini sesuatu yang sudah tidak dapat kita hindarkan lagi, bahkan banyak juga para pegiat di sini termasuk mahasiswa dan dosen yang sudah cakap dalam memanfaatkan kecerdasan artifisial atau artificial intelligence tersebut. Tentu kita harus perlu waspada dan berhati-hati juga dalam penggunaan dan dari AI ini, baik dalam guna mencegah penyalahgunaannya ataupun dalam menghindari potensi ancamannya dengan dapat memanfaatkan sebaik-baiknya artificial intelligence tersebut. Okay.
So what does globalization and digitalization do? By the way, the drawings in the slides, if you see them, they are not mine. I'm not doing this. I don't know where this comes from. So maybe you can do something about it. In any event, we know, everybody knows, that life itself, so the way people interact, the way business is conducted, the way the economy works, is both globalizing and digitalizing. The mere fact that I am speaking to you today, I'm sitting here in my in my study at home, actually in Germany, while after this talk, I will probably get in my car and drive to another country in the Netherlands where I work. And this morning, I give a lecture to you thousands and thousands of kilometers away in Indonesia. And within Indonesia, you are listening to me in many regions of the country. Imagine the dimension of globalization this alone represents. So we could easily also have listeners from other countries, from other corners of the world. It means that borders are really softening, and that digital tools are obviously helping with this. So we don't see it only in education, of course, but we see it, for example, in international commerce. So the volume of trade, which involves, of course, also legal transactions that cross international borders, is only ever growing. At least after the pandemic, it is growing again. Services can be rendered worldwide, such as the service that I have been invited to render to you today. But also, if you, for example, hire a freelancer, they can be based in another country. If you hire a lawyer, they can absolutely be based in another country. All kinds of services permeate and cross national borders all the time. So we have international commerce, we have worldwide provision of services through digital means, and of course we have the mobility of persons themselves and their assets, especially also if you consider cryptocurrencies on top of the normal moving of assets and money that we have. And lastly, I would also consider as one of the factors in globalization the political interdependence. Political interdependence, so the way in which the political dealings of one country interact and interdepend with those of another, should also play a role here, because it is not possible for any country to either regulate or to govern and manage its internal affairs without even looking at other countries. So all of these factors make our entire life globalized and increasingly digitalized as well.
Dr. Sasahar sudah menyampaikan juga bahwasanya pada saat ini kehidupan di seluruh dunia tidak bisa dihindarkan dari praktek globalisasi, digitalisasi, dinamika perkembangan manusia dan teknologi itu sendiri. Dan itu mencakup di beberapa hal seperti yang beliau misalnya tadi beliau juga mencontohkan beliau sehari-harinya berdomisili di Jerman, itu mobilitasnya setiap hari ke Belanda. Itu dengan adanya globalisasi sekarang tidak seolah-olah dunia itu seakan-akan tiada tanpa batas lagi. Nah, efek dari globalisasi dan digitalisasi ini juga sampai ke beberapa seluruh aspek yang beliau sampaikan, termasuk di dalamnya seperti perdagangan internasional, kemudian layanan jasa yang ada di dunia. Beliau mencontohkan tadi termasuk misalnya jasa layanan sekarang untuk pengacara, advokat saja sekarang sudah bisa kita secara digital. Kemudian begitu juga dengan mobilitas individu dan aset serta kepemilikan mereka itu sekarang karena pengaruh digitalisasi dan globalisasi ini juga sangat intens dan tinggi. Dan terakhir tentunya dalam konteks yang lebih besar lagi, adanya interdependensi politik di antara berbagai negara-negara dunia. Jadi negara-negara di dunia sekarang punya kecenderungan itu lebih untuk mengakrabkan diri mereka dalam suatu bentuk giat-giat yang di mana di dalamnya ada kerjasama atau kooperasi ataupun kolaborasi dalam rangka ini menyesuaikan dengan globalisasi dan digitalisasi ini. Next, Theo.
Since our entire life, our economic, social, and other transactions are globalizing, so is, of course, also the law itself. So one of the effects of globalization is that we have increasingly global law. Of course, the national law isn't lost. So national law continues to exist and continues to play a big role. But what we also see in the context of national law is that national law is increasingly interlinked, intertwined with norms that come from other countries, from the international sphere, and from other levels of regulation. So we have, of course, first of all, public international law. Public international law, of course, includes things like human rights law, the law that governs the interpretation and execution and conclusion of international treaties, the UN system, and so on. But it also includes relatively detailed regulation, for example, in the framework of the World Trade Organization, the WTO, or similar organizations to which many or most countries in the world are party. So this is law which stems from outside national borders, but which has an extremely important effect on what happens inside a country and between countries. We have next, in many corners of the world nowadays, the law of supranational organizations, such as European Union law. Inside the European Union, the law that is issued by the EU is binding. It has direct effect in member states, and it has supremacy over national law. So when we study law in Germany or the Netherlands or Spain or Estonia or anywhere else in the European Union, we are simply not finished if we know the law of that country. Or rather, we can't know the law of that country without studying European Union law as well. These are integral components of the law in these countries. Why should this bother you as Indonesia? Now, of course, there are similar emerging structures, for example, in the context of ASEAN, even though the supranational nature of these organizations is less so far. But imagine cases where, for example, an Indonesian company wants to market their products in the European Union or wants to market their products in the Netherlands. It is not enough to know national standards when it comes to packaging or contracts or other aspects of commercial transactions of the Netherlands. If you want to do that, you will have to engage, if you really want to understand how things work, with rules coming from the European Union as well. If the situation today were reverse and one of you would be giving a lecture in the Netherlands, you would very much have to take care that you observe standards of the General Data Protection Regulation, which is a piece of EU law that manages data protection throughout the European Union, and it has effects on what you can do online, the links you can provide there, who is liable for harmful content on the internet, can you publish things that you record while somebody is giving a lecture, under which conditions, and so on. So the law of supranational organizations is increasingly important. International industry standards are very interesting because these are rules that may not always be legally binding, but necessary to observe in order for commercial parties to operate internationally. International industry standards are usually not legislated top down from states and regulators and official so state-bound regulators, but they emerge often in the context of industry organizations and professional groups. Nonetheless, these are important rules in international life, especially when it comes to international economic life. And then, of course, because of these interactions between countries and the national mobility that I mentioned earlier of persons, assets, services, the need to understand the one or the other thing about foreign law, especially in specific situations. Because more and more often it happens that, I don't know, a person from Indonesia will get married to a spouse from the US, and together they may own a house in a third country. So you have the law of various countries involved when it comes to things like inheritance, child custody, contract law, whatever. So foreign law becomes increasingly relevant because of the mobility and because of the increasing number of international interactions that we see.
Baik, Dr. Sasa sudah menyampaikan juga bagaimana dampak dari globalisasi dan digitalisasi itu termasuk khususnya di bidang hukum. Beliau sudah menguraikan, memaparkan tadinya seperti di bidang hukum internasional publik. Nah, ini sangat mempengaruhi tataran dan perjanjian-perjanjian internasional atau konvensi-konvensi internasional yang berkaitan dengan hukum WTO misalnya, hukum organisasi perdagangan internasional, ataupun hukum international human right atau hukum HAM internasional. Kemudian dalam konteks lain, bicara dalam konteks Eropa, menyampaikan bahwa sekarang sudah ada hukum subnasional Uni Eropa namanya. Jadi hukum masyarakat Eropa itu di negara-negara anggota masyarakat Eropa dianggap sebagai hukum yang memiliki direct effect atau efek langsung bagi anggota-anggotanya, juga memiliki hierarki yang lebih hukum yang ada di negara mereka sendiri. Intinya di orang, barang, jasa, pekerja itu bebas termasuk. Nah, jadi ini juga pengaruh digitalisasi dan pengaruh dari globalisasi itu sendiri. Dan itu juga termasuk mempengaruhi standar-standar industri internasional. Nah, beliau juga menyampaikan, jadi setiap orang juga perlu saling memahami hukum nasionalnya masing-masing dan hukum yang berkembang di regionalnya masing-masing. Seperti orang yang mau produsen di Indonesia yang mau mengirimkan barang ke Eropa juga harus paham standar yang ada di sana, dan begitu juga sebaliknya. Kemudian juga di sektor pribadi, hukum globalisasi dan digitalisasi ini juga mempengaruhi hukum asing dan hukum privat. Nah, hukum perdata internasional seperti beliau contohkan tadi, misalnya masalah perkawinan. Jadi ada orang Indonesia misalnya ketika kawin misalnya dengan orang Belanda, memiliki aset di Perancis misalnya, kemudian juga punya harta bergerak di Inggris, kemudian bercerai misalnya di negara lain, itu bagaimana warisnya, bagaimana pengawasan terhadap anak, pemeliharaan anak, harta gono-goni juga tentu harus dipahami. Jadi hukum itu sekarang saling berinteraksi antara hukum nasional masing-masing negara itu dalam konteks globalisasi dan digitalisasi tersebut. Next.
Thank you. So because of all of this, so because our lives digitalize, and because as a consequence also the law increasingly internationalizes, globalizes, and digitalizes, so will legal careers. So if I look at the room that I can see now here in the Zoom meeting, I see a great hall full of students at the Fakultas Hukum in Bukit Tinggi, and there are other places where I see students as well, you will all enter a legal labor market, which one way or another will have globalized and which will increasingly also have to make use of digital tools. Of course, this can be to different degrees. If you are a lawyer in private practice in some sort of small local place, a village in Indonesia, of course, the transactions you deal with will be predominantly governed by Indonesian law. But also Indonesian law itself will be influenced by international legal standards. For example, trade rules coming from the WTO, for example, international treaties and so on. So in order to properly understand your own system, also for this, a knowledge of globalized law, if you want, is useful. But if you move away from the very local situations, so governing local disputes, governing local family law, etc., into anything that is remotely international, anything that has to do with trade, anything that has to do with businesses operating internationally, anything that has to do with the public sector and touches upon interactions with the outside world, you will have to have an understanding of law from outside the purely national context. And therefore, regardless of whether you end up in private practice, being an attorney, whether you end up working for the government in the public sector, or whether you end up somehow in the world of business and industry, you will have a career which is at least impacted, if not making use actively of globalized legal contents, because transactions that you deal with are globalizing, and the rules that you deal with as lawyers are also globalizing.
Globalisasi dan digitalisasi juga sangat mempengaruhi karir hukum ke depannya. Apakah nanti kita berkarir hukum dimanapun, apakah itu dalam praktek swasta seperti pengacara, notaris misalnya, atau kita di sektor publik ya seperti analis perundang-undangan, legal kontrak ya. Kemudian juga di dunia bisnis dan industri. Nah, ini dikarenakan karena memang fenomena yang terjadi itu sekarang semua bentuk transaksi itu sudah semakin mengglobal. Jadi tentu ini akan mempengaruhi bagaimana bentukan karir seorang yang akan lulus di Fakultas Hukum. Nantinya juga tentu harus dibekali pendidikan yang tentunya menampung, mengakomodir digitalisasi dan globalisasi ini.
So what does this mean for legal education? Should it mean that we simply have to teach, the law of the entire world? Is it not enough anymore to learn Indonesian law? Should we also learn the law of all the other countries, or at least the most important ones that Indonesia has dealings with? A little bit of EU law, a little bit of public international law. Well, to an extent, yes, but this of course does not mean that you should just stack another couple of years onto the legal curriculum in order to be fully prepared for this type of 21st century legal career. Predominantly, it should mean that the curriculum should reflect that law is globalizing. So this does not necessarily mean learning rules upon rules from different countries, but it can mean that we can approach law in another way. We can approach law, for example, a little bit conceptually. The laws of all countries and also the laws of international rule-giving institutions international law, public international law itself, the WTO, etc., all try to answer certain questions that the systems all have in common. Therefore, on the one hand, comparative law, so asking the question, how does Indonesia deal with a certain legal question that poses itself in the same way in another jurisdiction, such as the Netherlands, is worthwhile because it teaches us something about law in general. So a comparative approach can give us, in the abstract, but generally a better idea of what law is doing, how law is having its effect on its subject matters. The second that should be done is to generally make it a habit, especially for those people who develop the curriculum, so people in ministries, but also at universities itself, to increasingly implement what I would like to call a layered approach to national law. So when we teach national law, when we teach private law, for example, or when we teach anything in public law, that we highlight the interactions between the norms that we teach, our regular national norms, and other levels of regulation. So many norms in economic law, for example, are heavily influenced by norms that come from outside our own jurisdiction. The same is true for norms in other domains. I myself am a constitutional lawyer, and of course there are interactions between the constitutional systems of one state and another, not just because of intellectual transactions, but also because of legal traditions that cross national borders and permeate historic developments, but also because membership in, for example, ASEAN or the European Union also shapes the constitutional system of a country. So taking a layered approach, always considering various levels of regulation, is already very helpful in incorporating the globalizing character of law in the 21st century. What helps also is to take a more conceptual approach, at least at the beginning. So when we talk about norms, let's not just memorize them. Let's not just tell students to learn the phone book by heart, as it were. No phone book exists anymore, but to learn long lists of rules without thinking about them. But let's try to really understand what legal norms are about, how they come into being, how they interact with one another, because this enables us to also understand the complexities of globalization better. And lastly, and I think this is the most important point, globalization of law, and when we have to deal with it in teaching the law, does not mean that you really have to study the law of other countries in very much depth. If you have the right toolbox, if you have the necessary skills, the necessary versatility, and the necessary base knowledge of law at a conceptual level, you are very easily able to adapt to a new system. We see this, we have a lot of experience in this in Maastricht at the European Law School, the program in which I mainly teach. It is an undergraduate program, and it is not a program in Dutch law specifically, or in any national law specifically. And it has a student cohort with over 70 nationalities. So people in this program really come from everywhere in the world. And when they graduate, they also go back to everywhere in the world and work in various legal professions, from the toga professions to in-house counsels, to consultants, to government services, everything. Now, what enables people to study law in an obscure small backwater city of the Netherlands and later go back to Australia and work for an IT company, or to come from Indonesia, study in our program and go back to Indonesia and work for the government there? What helps them is that the teaching approach that we take is not only on learning more and more and more concrete rules, but on developing the skills that you need to hop between systems, to change between systems. If you understand the systematicity of law, you are more easily able to adapt to the situation in whatever jurisdiction you end up in, because structurally, if you are able to recognize patterns, if you are able to understand systems, and to understand that the regulation of one country in a certain legal situation is just another answer to the general legal question on the matter, you will be able to adapt, and you will be able to use the skills that you have learned to become proficient in any system quickly.
Dengan digitalisasi dan globalisasi ini, konten dari pendidikan hukum juga seharusnya menyesuaikan dan mencerminkan sesuai dengan perkembangan yang ada ini. Nah, ini masuk dalam beberapa konteks, misalnya dalam konteks pembelajaran berkaitan dengan perkuliahan mata kuliah hukum perbandingan atau perbandingan hukum, ya. Apakah perbandingan hukum pidana, tata negara, maupun perbandingan hukum perdata misalnya. Kemudian satu hal yang ditekankan tadi juga dalam konteks pengajaran hukum, Dr. Sasa menyampaikan apa yang beliau sebut sebagai layer approach. Jadi pendekatan berlapis terhadap hukum nasional. Jadi di sini maksudnya adalah menyoroti interaksi antara hukum nasional, hukum supranasional atau regional, sampai ke level hukum tataran hukum internasional. Jadi oleh karenanya baik dari pengajar sendiri atau mahasiswa sendiri perlu memahami hal tersebut. Jadi melakukan pendekatan yang berlapis terhadap hukum nasional. Jadi kita hanya tidak terpaku untuk mengkaji hukum nasional kita sendiri, tapi juga melihat perkembangan yang lebih jauh lagi di tingkat nasional, regional maupun internasional. Kemudian juga memakai pendekatan konseptual, dan satu hal yang beliau tekankan juga salah satunya kita harus fokus juga bagaimana untuk menghasilkan istilahnya nanti lulusan yang itu memiliki keterampilan hukum yang dapat menyesuaikan dengan perkembangan globalisasi dan digitalisasi tersebut. Baik itu di tingkat program sarjana ataupun pasca sarjana. Beliau mencontohkan misalnya di Maastricht University itu pendidikan hukum itu kelas banyak juga kelasnya sangat kelas internasional. Itu mahasiswanya dari berbagai negara. Tapi ketika mereka kembali ke negara mereka, apapun profesi mereka, apakah di sektor publik, pemerintahan, swasta, pengacara, notaris misalnya, ataupun perancang kontrak ataupun peraturan perundang-undangan, mereka memiliki keterampilan atau skill yang sudah bisa beradaptasi dengan digitalisasi dan globalisasi tersebut. Next.
Now, this is all still relatively abstract, but how should we do this? What methods can we use to implement this? To, for example, heighten the focus on skills. I know that in Indonesia, what frequently still happens, and not only there, also in my own home country, in Germany, this is still very prevalent elsewhere in the world, that the focus is still very often very much on learning the norms, also learning specifically national norms and memorizing things. But memorizing things won't bring you very far in terms of the skills that I mentioned. So the ability to apply rules, also creatively, the ability to take a case that you have learned about, maybe study case law, and imagine what this means for a novel case that you will encounter in your professional practice. So what can we do in order to bring these international contents, the globalized contents of the curricula that I have been mentioning, and the need to focus on skills and to take a layered approach to national law, to bring this into reality? In order to answer that question, we first have to wonder what aims do we pursue in choosing a legal method, a teaching method? Of course, we want that students memorize, retain as much of the knowledge as possible of what they hear. So wouldn't it be nice if a student could sit in a lecture and just memorize everything word for word that the lecturer is saying later? There is a very strong echo. Maybe somebody needs to mute themselves. Yes. So wouldn't it be nice if a student could just memorize everything that the lecturer is saying or that they are reading on the slides or in the book? But the fact of life is that they can't. This is about the least effective method of knowledge retention. So there are other methods that should be used to do that. Second, what we want to do is foster understanding rather than just memorizing, because regardless of how much I memorize, that doesn't mean yet that I can apply my knowledge in a situation that is novel or foreign or complex or crossing borders and so on. So understanding is better than mere memory. What I want to do by choosing a teaching method is enable students to increase the so-called transfer performance, so the ability of students to apply knowledge that they have learned in one course or in one particular case to novel situations which they later see in their professional practice. This is what we want to do because this enables them to be good functioning lawyers in a labor market of the 21st century and to have easy adaptation, because 20 years ago, maybe 40 years ago, it was relatively clear that if I'm a student and I go to study law at an Indonesian university, that I will end up either in private practice in Indonesia or in government service in Indonesia, or somehow in the industry within Indonesia. And the chances that I have to do with content from outside the Indonesian jurisdictions were relatively slim. This is absolutely no longer the case. When I'm a graduate of an Indonesian faculty of law, I hardly can avoid getting into contact with contents that are that originate in this globalized world. So we want to do good knowledge retention, we want to have understanding, we want to have good transfer performance, and we want students, graduates, to be easily adaptable to whatever job they end up in. And in order to do this, we need to choose a method which really focuses on the acquisition and the activation of skills, such as analytical thinking, such as case solving. And this is really tricky. Case solving is not easily done. You don't have to imagine that if you only know enough law in your head, you can solve cases. Case solving is a skill that is quite distinct from having memory of the rules that apply. You want soft skills because people may need to work in intercultural and international teams. They may have to work with people who are very different from themselves, culturally, intellectually, whatever. And you want, of course, digital skills and information literacy, because some decades ago, actually still when I was a student, which is not that long ago, it was the beginning of the 2000s, studying to a large extent consisted in going to the library and reading the books that were there in the library. Today, there is, of course, much more information available to everyone at their fingertip. You just have to Google things. You are flooded with information. So today, the problem is not so much finding information. The problem is distinguishing good and useful information from bad, useless, and false information. This is what, among others, what we refer to as digital literacy, and it is an extremely important skill for everybody who works in law today, everybody who works in education or who is being educated today. So these are the things that we want to achieve in choosing a teaching method.
Jadi beliau menyampaikan juga bagaimana metode pengajaran hukum yang akomodatif dengan digitalisasi dan globalisasi tersebut. Yang pertama, beliau menyampaikan tadi ada beberapa hal yang harus kita lakukan, pemahaman yang tinggi tentang retensi pengetahuan. Kemudian satu hal yang sangat penting untuk diberikan kepada mahasiswa, misalnya itu adalah lebih memperkuat pemahaman ya, daripada sekedar hanya mereka menghafal fakta-fakta yang ada. Jadi lebih mendorong bagaimana pemahaman terhadap teks dan konteks dari ilmu hukum itu sendiri. Kemudian meningkatkan kemampuan ya, kemampuan dari mahasiswa tersebut. Jadi istilahnya di sini skill dari mahasiswa itu ditingkatkan yang adaptif dengan perkembangan digitalisasi dan globalisasi tersebut. Kemudian juga meningkatkan bagaimana mahasiswa itu nanti juga mudah beradaptasi dengan perkembangan zaman, termasuk globalisasi dan digitalisasi. Dalam konteks ini perlu ada beberapa keahlian atau skill yang perlu diakuisisi dalam yang harus diberikan kepada mahasiswa. Yang pertama itu adalah kemampuan untuk dalam beranalisa, berpikir secara analitis. Nah, kemudian kemampuan dalam memecahkan suatu persoalan, penyelesaian kasus. Kemudian suatu hal jangan dilupakan juga kemampuan interpersonal. Dalam hal ini adalah soft skill. Jadi soft skill ini memegang peran yang sangat vital juga, seperti kemampuan mahasiswa dalam berinteraksi, berkomunikasi, kemampuan bekerja dalam tim misalnya. Terakhir tentu adalah keterampilan digital dan literasi informasi. Beliau menyampaikan sekarang tidak susah kita untuk mendapatkan literasi secara digital. Kalau dulu orang harus datang ke pustaka atau mencari bukunya terlebih dahulu. Tapi sekarang kita sudah dibanjiri oleh informasi itu sendiri. Nah, satu hal yang penting adalah sekarang bagaimana mendapatkan informasi yang berguna dan baik. Ya, jadi kita karena sudah banjir informasi ini banyak juga kiranya yang itu tidak berguna dan sama dengan sampah dan juga tidak bermanfaat sama sekali. Inilah yang perlu kita apakan untuk dalam mendapatkan literasi informasi ini.
So therefore, what tools can help us to achieve this? So what methods can we choose? One, of course, and it won't surprise you because this is something I have been working on and working in for a long time at home in the Netherlands and in Indonesia, is a problem-based learning. But I get to this. So learning should be what we call in our system in Maastricht University, in our teaching vision, we call it CCCS, and I think in Indonesian could be KKKS. So we have that learning should be constructive, it should be active, we should build knowledge rather than just passively consume knowledge from a lecture or from a book, because knowledge that we have built ourselves is easier for us to use and to apply in practice. Knowledge should be learning should be contextual. So it is easier to understand and to memorize and to really penetrate a case if I can place it in a story. So rather than learning by heart the criminal code, I should learn on the basis of actual or hypothetical cases. Often hypotheticals are even better, because if I have a little story in whose context I learn things, and also if the content of what I'm learning is actually relevant. So for example, at the moment, something that is very relevant to understand many developments in constitutional law are questions of, for example, climate change or current affairs problem. Of course, at the moment, if you teach international law, you will not get around speaking about the Middle East conflict between Israel and Palestine. So these are all things that you should be discussing in class. Why? Because it provides context, it provides relevance to what you are teaching, and as a student, what you are learning. Then learning should be collaborative. Why? Because work is collaborative. Regardless in what job you end up later in your career, you will have to work with other people. And the more efficiently you can do this, and the better you learn doing this already in your undergrad and graduate studies, the better a lawyer you will later be. And lastly, study should be self-directed, because the labor market today is rapidly shifting from a place where you at least start your career as an employee who receives directions from a superior and then does exactly as the superior says, to a labor market in which also entry-level jobs come with a high degree of self-organization, self-direction, self-sufficiency, because you may be sitting somewhere in one place in the world and collaborating with somebody behind a laptop elsewhere in the world. So you have to be able to self-direct and self-organize. So these are another. I use one more slide so to bring this to a conclusion. These are the aims that we pursue and the methods that we want to be using. But what are actual concrete tools? Let me add those to this. Of course, one concrete tool is problem-based learning. Problem-based learning means that we don't start from the rule, for example. When I teach you about criminal law, I won't first give you the definition of stealing and the article number in the criminal code, and then expect you to be able to qualify later in your life when you encounter a client or when you have to judge a case, whether something amounts to stealing or not. I start the other way around. I provide you with a story, and it is you as a student who has to figure out what is the problem here. What questions do we need to ask? What is the lesson in this? What part of the law does this concern? Etc. Why? Because in real life, regardless of what job you're in all the legal jobs, problems that you have to solve don't come to you in a structured Excel sheet kind of way. They come to you in the form of stories. Your boss coming to you in a company asking you, okay, we want to make this commercial transaction. What kind of contract do we need? They tell you a story of what they want to do. You have to answer the legal problem. A client comes to you in private practice. They have a legal problem with their neighbor. They tell you a story. You have to understand what the legal problem is and how to solve it. In government service, the same story. So wherever in work, legal problems don't come as prefab documents, they come in the form of stories. So problem-based learning really prepares for practice in whatever job. This can be helped by mooting and simulations. I know that Indonesia has a wonderful moot court tradition, and I think it can be even further expanded. Very often, moot courts in Indonesia take the form of a very theatrical form of simulations of all the roles in the courtroom, so prosecution, defense, and judge. But mooting simulations can be brought a little closer to practice even, and they are a great tool to augment the curriculum. Think tanks and clinics, so students working on real-life problems for real-life clients under guidance of lecturers. Clinical education is very, very useful in bringing curricular content to life, also when it comes to problems that have to do with globalized content and digitalized content. E-learning. Of course, we all do this. We have had to learn it very fast during the pandemic. We have learned to teach online. We have learned to study online. But of course, there are tools that we don't have to give up again and that we can continue using, such as webinars as we are doing today. Internships, I very much encourage, and in the book that we mentioned at the very beginning of the lecture, this has also been mentioned and described at length. Internships are a very important way to bring students and to bring universities and the labor markets and employers closer together, which is highly needed today. Now, let me come to one important aspect: internationalization. Internationalization of education is not easy, especially if you are not in the Oxfords and Harvards and the big shot universities in the world, where students and staff are highly internationally mobile anyway. But digitalization can help us. Today is a good example. We are having an international conversation right now. We are engaging in internationalization, but we can do more. Students can have exchanges, of course, and wherever that is not possible for practical reasons, we can have virtual exchanges. For example, the Faculty of Psychology at my university is collaborating with a number of Indonesian universities where student groups from both sides collaborate over longer periods of time actively in working on common educational problems. So basically PBL in an international classroom online together. International collaborations. You can have collaborations even at a very low-key level. Through digitalization, it is not so hard to set up. This can be virtual. This can also include what we call internationalization at home. So to give you one little example, I'm sorry, I'm talking longer, so the translation might also take longer. I didn't expect it. Anyway, a small example from my own work. I'm currently in the process of setting up an internationalization at home project together with the University of Nusa Cendana in Kupang, where students from the Netherlands will actually physically go there for an amount of time, and together with students there on an equal footing, so not knowledge transfer from the Netherlands to the Indonesian students, no, equal footing collaborations between students there and lecturers there and ourselves and our own students working on a project. For the Indonesian students, this is beneficial because it provides internationalization at home, whereas they might not be able to go on a long and expensive exchange. And for our students, this is equally beneficial because also they are exposed to the international experience. So if you look at this toolbox, together these things, I hope, give you some inspiration for what can be done to implement and to really react adequately to the trend of globalization and digitalization without needing to study the law of all the other countries. Of course, we cannot make the curriculum so much longer and so much heavier. We need to shift the focus and we need to adapt the method. That is a little bit the method, the message that I want to give you today. Sorry for the lengthy translation that you will have to go through.
Okay, never mind. I will translate. Jadi Dr. Sahar juga menyampaikan tadi bagaimana metode pembelajaran di Maastricht. Tadi ada yang disebut triple CS. Jadi konstruktif, kontekstual, kolaboratif, dan self-directed. Jadi konstruktif itu pembelajaran secara aktif. Sedangkan kontekstual itu yang dibangun adalah bagaimana kurikulum itu isinya muatannya diarahkan atau relevan dengan kondisi kenyataan kehidupan sehari-hari ataupun kasus-kasus yang ada. Kemudian juga kolaboratif ya. Jadi bagaimana melibatkan mahasiswa untuk dapat bekerja sama dan berinteraksi secara aktif dengan yang lainnya. Jadi kalau di Maastricht itu ada kelas dibagi, ada kelas perkuliahan, ada kelas tutorial. Kelas tutorial itu hanya maksimal diikuti 15 orang. Jadi di sana mereka berinteraksi dengan aktif dalam membedah atau menganalisa, mengkaji ataupun berdiskusi terhadap suatu persoalan yang dijadikan topik perkuliahan. Kemudian juga self-directed, jadi mampu mengelola dan menggerakkan proses pembelajaran sendiri. Nah, dalam konteks tadi lebih luasnya di Maastricht, metode ini disebut juga dengan PBL, Problem Based Learning, pembelajaran berdasarkan masalah. Nah, inti-inti dari PBL tadi disampaikan oleh Dr. Sasa, diantaranya materi-materi muatan atau kurikulum pendidikan hukum di Fakultas Hukum Maastricht, seperti adanya perkuliahan-perkuliahan yang berkaitan dengan peradilan semu dan simulasi praktek-praktek hukum. Kemudian juga ada klinik pendidikan hukum misalnya yang juga kita juga punya saat ini. Kemudian tentunya adalah pembelajaran secara e-learning. Jadi e-learning ini sifatnya edisional aja ataupun tambahan. Kemudian juga ada program magang. Kemudian satu hal yang penting dalam konteks globalisasi dan digitalisasi adalah adanya program yang disebut sebagai internasionalisasi. Nah, beliau mencontohkan tadi misalnya pertukaran mahasiswa secara internasional. Tidak harus secara fisik, tapi juga bisa dilakukan secara online. Misalnya mahasiswa seperti yang sekarang kita lakukan, kita mengikuti perkuliahan-perkuliahan yang ada di Fakultas Hukum di Maastricht misalnya. Kemudian juga bisa kolaborasi internasional tadi. Beliau juga mencontohkan ada beberapa mahasiswa di Belanda juga di Maastricht mengikuti program ini di Kupang. Jadi mereka mengerjakan suatu proyek yang nantinya tentu hasilnya nanti ada dalam dimuat dalam bentuk karya tulis misalnya. Jadi itu yang beliau sampaikan, bagaimana PBL juga menjadi salah satu metode yang bisa digunakan dalam rangka mengadaptasi atau mengakomodir digitalisasi dan globalisasi tersebut. Next to you, Sasa.
Thank you very much. One more word on PBL. You may have heard or actually been in one of the trainings. We are still continuing to provide problem-based learning training for capacity building, staff training, but also presentations for students. Together with our network, the JAPI, which I presented in the beginning, and our partners at Erlangen University who organize this. And it is possible also in the future, we will continue doing this to have collaborations between the project partners, ourselves in Maastricht, and also new universities who haven't been partners in the project in the past. So for example, in a couple of weeks, I will also be visiting the University of Northern Sumatra in Medan to conduct such a training. So if you're interested in this with regard to PBL specifically, also feel free to stay up to date via the network website. That just aside. So these are all tools that we can use to bring our education slightly closer to the realities of globalization and digitalization. One trend in this, which of course I cannot leave you without mentioning it today, is artificial intelligence. So if I don't see the class, so there's a classroom at UNIP that I can see, and there used to be a classroom in Bukittinggi that I could also see here in the Zoom meeting. I can't see them right now anywhere. Well, the classroom in UNIP I can see. What I would like to do actually, if you are in the room, Paferi, for example, in Bukittinggi, do a show of hands with the students. Who of them is using AI? Who of them is using ChatGPT in their studies? I want to know. And who's admitting it? how many of your students do you estimate are already using artificial intelligence, generative artificial intelligence?
Dr. Sasa menanyakan apakah di antara kita sudah ada yang menggunakan secara aktif artificial intelligence ini, baik mahasiswa ataupun para desain. Excuse me, Sasa, what do
Yeah,
you mean by the real AI?
ChatGPT, for example. Who's using ChatGPT?
Chat.
ChatGPT.
Yeah, almost I use the AI.
Yes,
Maybe once. Yeah.
almost everybody does. And our students, it's the same. So I have a mixed message. So of course, we all know, and this is what the teachers at universities still focus on, and I'm not so sure this is correct, but this is one side of it. It is dangerous. Huh? Why? Because it permits fraud. So it is not a good idea anymore, for example, to ask students for certain types of homeworks and essays that permit for AI fraud, because AI simply does it better and faster and easier than any one of us could. But it also often returns false information. There is the now almost anecdotal, but it's a real case from New York at the beginning of this year, only 3 months after the launch of ChatGPT. New York City, a relatively boring legal case. Somebody had taken a flight with a Filipino airline, Avianca, and they had been injured during the flight because a stewardess hit their knee with an airplane trolley, and they wanted compensation for this. Now, there is plenty of case law in America suggesting that this is not something you can get compensation for because it involves a degree of risk-taking. You shouldn't have stuck your knee out, etc. However, this client had a lawyer who asked ChatGPT, now, give me precedence, case law that says that I can get compensation for my client in this case. And ChatGPT gave them 10 cases, wonderful cases, marvelous precedents on the basis of which they could claim compensation for the knee injury of the client. And only later, when the judge looked into these arguments, looked into these precedents, it turned out that ChatGPT had invented every single one of them. So there was a lot of false information, literally false information being hallucinated, being invented by AI. So false information is also a problem. And lastly, we are getting used, or many students are getting used to using ChatGPT like they use Google. But that is problematic because ChatGPT, even less than Google, forces you to make your own selection. It just gives you one single ready-made answer. You don't even have to choose from various answers anymore. But it is not a very good search tool. The only thing it is really good at is language, not searching the internet. So there are all kinds of dangers attached to using artificial intelligence, using tools like ChatGPT and others like Bard, which are now being launched. However, does this mean that we should not use it and that we cannot use it in a constructive way? I think no. I think there are wonderful uses for ChatGPT. It does mean something for the way we teach, however. I already said there are certain types of questions we can no longer ask in homework, in essays, for example. I can no longer ask factual questions because essays about factual questions, at least if the answer is not too recent and not too complex, etc., ChatGPT will do in an instant. I have to ask other types of questions which ChatGPT is not good at solving. For example, asking questions that involve value judgments. What I can also use, both as a student and as a teacher, AI for constructively, where it is an enrichment of legal education, is, for example, writing assistance. And here it becomes very interesting, not just for us as educators, teachers of law and students of law, but also as researchers. Most people working at universities both have teaching tasks and research tasks. And a common problem in this is that if we want to be successful, we have to publish internationally. And in order to do that, we have to hand in absolutely flawless abstracts in a language which might not be our first language, such as English. To do this, for example, to assist us in writing good abstracts, to assist us in writing correct English. So without cheating, without plagiarizing, without having our content written by the artificial intelligence, we can use it as a tool to improve our writing. Translation. You might not be surprised that all of the translations I used in this lecture have been made with the help of artificial intelligence. For teaching staff, it can even go further. So artificial intelligence can help us, for example, with the construction of hypotheticals, with the construction of questions, and so on. So there are uses of artificial intelligence which are extremely helpful and which not only should, but I think in the very near future have to be incorporated in the way we teach, because they are not going away. They are not going away from professional practice either. This is almost the last slide, but I would like to very briefly, just for 5 minutes, stop the presentation and instead switch to a little illustration of what I've just been doing. I know that the students are very familiar with the system, but maybe not all of the lecturers are. So I would just like to give you an illustration of the power of the system, for which you should, of course, bear in mind that it also comes with the dangers that I mentioned. So I'm going to briefly switch off the PowerPoint presentation and instead share another screen that I have open with the well-known ChatGPT tool. So now you should be seeing my ChatGPT mask. Do you see it? Okay. Now this is very interesting for, and what we should be using it for is to improve our writing, as I said. What we should not be using it for, and we shouldn't underestimate how disruptive this is to the way we teach the law, is of course to ask questions which permit students to cheat with this. For example, I can very easily give a prompt to ChatGPT that goes something like this. I'm typing into the mask, write an essay of, let's say, a very brief one, 400 words, explaining the new Indonesian omnibus law. Do this in Bahasa. There we go. And it starts generating, and it does this very fast, and the language of it will be flawless. Depending on what you are asking, the information contained in the essay might be wrong. So it is not a good idea to do this. But it is also not a good idea for lecturers to ask this type of question, because this is a question of factual reproduction. We simply should not be asking those anymore. It was already not a very good question before ChatGPT, but since we have ChatGPT, it is just not making any sense anymore, because we are not asking students to do any actual work anymore. What we should be doing is ask questions like, is the new Indonesian omnibus law a good thing? And then ask questions to ask students to come up with arguments for either side and to take a stance. Because taking a stance, adopting an actual position, making a value judgment, whether something is good or bad, etc., is something that ChatGPT is not good at doing. It won't do it. It is not programmed to do it. It is very hard to get it to do it. And when it does, it is very awkward and often very wrong. So this is something. But the other thing I mentioned, since I know that most of you are not only lecturers, but also researchers who have to publish something where it is very powerful, is to assist in writing without plagiarism, without copying, or without using it as a ghostwriter. When I, for example, have a text and my English is sort of insecure, my English is not perfect, and I'm going to demonstrate this by using a sample text that I made before this talk. And I paste it in here. So this is a line of, these are 2 lines of text and they are full of mistakes. This is bad English. This text badly written, example for how to do not, with little help from intelligence artificial, can make it into easy to understand text, can also make it sound almost academic. So this is bad English, right? Everybody agrees. I can't do this in Bahasa because my Bahasa is much worse than this. But everybody agrees that this is bad English. I can give ChatGPT the prompt to please transform the following into correct and academic level English. It will do this immediately. And the result is good. The provided text is poorly composed and serves as an example of what not to do in writing. With the assistance of artificial intelligence, it can be transformed into a more comprehensible and academically sound piece of text. This is flawless. So these are things that we can easily use ChatGPT for, to the benefit of everybody. And I would recommend everybody to incorporate this in the work they do, especially if you aspire to publish internationally. This short demonstration, I could do much more, but actually the 90 minutes are almost up. So I will stop at this point, go back to the PowerPoint presentation. Wait, let me share it again. And actually with this also finish this morning's talk, because I hope we can still have some time for questions and answers. Thank you very, very much for your kind attention and for bearing with me. And I'm happy to still answer a couple of questions. Thank you.
Oke, di akhir presentasi, Dr. Sasa sudah menyampaikan topik yang ketiga mengenai penggunaan dan pemanfaatan artificial intelligence dalam pendidikan, termasuk di dalam pendidikan hukum itu sendiri. Jadi beliau mencontohkan artificial intelligence tadi, penggunaan chat GPT yang sangat masif dan banyak juga digunakan sekarang, baik oleh mahasiswa sendiri ataupun oleh para dosen sendiri. Nah, tapi beliau juga menyampaikan ada hal-hal yang perlu kita waspadai juga terkait dengan penggunaan pemanfaatan artificial intelligence seperti ChatGPT tadi. Yang pertama, untuk bahayanya bisa jadi itu terkait adanya informasi yang palsu, yang tidak benar dari AI tadi. Kemudian juga adanya penipuan. Nah, ini penipuan ini karena ada dari apa yang dilakukan oleh pihak-pihak dari luar atau orang lainnya. Kemudian AI ini juga lah bukan sebagai alat pencarian yang baik menurut beliau. Kemudian tapi di sisi lain juga AI bisa digunakan dan memberikan manfaat seperti dalam hal membantu dalam penulisan. Ya, jadi penulisan apakah sepertinya koreksi bahasa, ringkasan ataupun kesimpulan. Kemudian juga bisa membantu dalam terjemahan. Jadi dalam menerjemahkan suatu artikel ataupun jurnal misalnya. Kemudian bagi para pengajar juga bisa sebagai alat bantu ya untuk dalam rangka membuat mengkonstruksi hipotesis yang akan mereka buat ataupun pertanyaan-pertanyaan yang berkaitan dengan materi-materi dari perkuliahannya. Jadi tadi beliau juga sudah menyampaikan bagaimana contoh secara praktek dari penggunaan chat GPT tadi. Barangkali itu yang telah beliau sampaikan kurang lebih selama 90 menit. Sekarang let us move into question and answer session. Kita masuk ke sesi tanya jawab. Silakan Bapak Ibu yang hadir secara online itu untuk tunjuk tangan ataupun diketik di kolom chat ya, di kolom chat ataupun yang hadir langsung silakan untuk tunjuk tangan. Untuk sesi pertama kita buka tiga penanya. Yang pertama sudah ada dari mana tadi di chat ada? Sudah ada di chat? Tadi ada yang raise hand di yang di ruangan. Oh silakan. Kalau bagi siapa yang bisa bahasa Inggris boleh langsung ditanya dalam bahasa Inggris ya.
Cek, cek. Assalamualaikum warahmatullahi wabarakatuh.
Silakan answer the
Okay,
question and say your name.
I'm Citra Sunia, and I'm fifth semester student from Muhammadiyah University of Dewa Sumatera. What we both know is that now the world global and digital era and uses AI technology. And right now I have two questions, and I'll ask you about it. The first, how it is the development of legal education with the existence of AI. And two, how to maintain the pureness of legal education for AI development. Only that, please answer. Thank you, sir. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much for these questions. So if I understand the question correctly, is how to reconcile legal education with AI and how to incorporate AI in legal education. I hope I understood the question correctly. So, of course, the beginning of the story is that we must, like we always had to, guard against cheating. But the story is not so simple, because not all users of AI are cheating, and also it would be very short-sighted thinking to brand the use of AI as cheating generally. Why? Because AI is going to be used in your professional life. It is going to, and it will be legal, and it will hopefully be regulated in some way, but you will have to learn how to use it. So just as some decades ago, use of the internet became normal, use of AI is also becoming normal. What can legal education do? First of all, we have to adapt the way we ask questions. I gave a very, very quick overview of that already, but I think we can have an entire webinar or seminar on this. We have just finished starting our new curriculum, starting our a new course, which I had to coordinate, where we had to think very well and hard about how to actually do this. What questions can we still ask? What makes sense? And how can students also use AI constructively? So legal educators should really spend a lot of thought on this, but I assure you there are users which are not only legal, so they don't constitute cheating, but which are also very, very handy, very useful, both for the students, for the educators and for the graduates who will later enter the labor market with an additional skill. Many legal educators in the world are still figuring this out. We are constantly developing new questions, and also ChatGPT and other AIs are also developing, and they are becoming better at things. So this is a dialogue, a process that will continue for the foreseeable future. But I would argue that we should not be afraid of this, but that we should try as much as possible to work constructively with it. I hope that answered your question to a degree.
Baik, jadi sudah dijawab oleh Dr. Sasa tadi bagaimana konteks AI ini dalam pengembangan pendidikan hukum ya. Jadi intinya adalah bagaimana pemanfaatan dan penggunaan AI itu sendiri secara bijak dan baik. Jadi bukannya kita tidak ke depannya barangkali terkait dengan penggunaan dan pemanfaatan AI ini juga perlu ada regulasi hukum yang akan mengaturnya supaya bagaimana AI ini dapat diterima sebagai bagian dinamika perkembangan teknologi yang bisa digunakan dalam pendidikan, termasuk di dalam pendidikan hukum itu sendiri. Ini ada dua partisipan yang secara online bertanya. Kita sebentar dulu yang online dulu ya Pak ini. Ada yang online sebentar. Hah? Dari sini udah ada. Nah, silakan. Sebentar Pak ini. Silakan yang untuk nyalakan kamera, unmute suaranya. Siapa tadi, Maulana atau siapa tuh? Ya silakan, Maulana. Suaranya di unmute.
Oke, sudah. Oke, terima kasih Pak. Bismillahirrahmanirrahim. Good morning, Dr. Hart.
Good morning.
Yeah, I heard earlier that you are in Germany right now, so it's still early there, right? Yeah. My name is Maulana, and I'm a student from Muhammadiyah University. Currently, I am on my third year. So there are several questions I want to ask you, Dr. Hart. My first question is, as a legal student, of course, we cannot always rely on programs provided by the university or the government. Although it is inevitable, I still have high hopes for it. But anyway, I'm currently co-founding and developing a local startup company and community related to empowering the youth generation, such as millennials and Generation Z, especially in the field of legal education. It's called Mahat Institute. So I want to ask you for your advice on how to accelerate it and how to elaborate it with the artificial intelligence into it, and how to build a reliable international networking as a legal student. That's my first question, Dr. Hart. And my second question, last but not least, I want to ask you about slightly sensitive issues. First of all, I want to apologize if I might offend you in this question due to my lack of research into your background. But I think I need to ask this. But also, you also mentioned earlier, I want to raise an issue and awareness about what is happening now in the Middle East, especially the never-ending Israeli and Palestinian conflict. I see even now that the war is seeing how hypocritical the European citizens are in the viewing of this conflict, and even have the double standard if we compare it to the Russian-Ukrainian conflict. And you also maybe probably already know before that the Indonesian people and even our government in its constitution will always stand with the Palestinian for their independence and seek a peaceful path between the conflicts. And my question is, I want to ask you what about your perspective as a European citizens and also someone who is also expert in the field of international law. How are the world and the European legal circle currently responding to this conflict regarding international law that has been violated, and what the ideal approaches can be immediately taken for a peaceful resolution between the Israeli and the Palestinian from a legal point of view or perspective? Thank you very much, Dr. Hart.
Thank you. Thank you very much for these questions. Now, starting with your first question, which of course is the less sensitive and in some ways the easier one, but still a hard one to answer. I think that international networking, especially for such projects or startups as you are currently involved in, is extremely relevant. I'm not exactly sure what the goal of the startup is or the service that you are providing, but in general, if it is a startup that gives assistance to students or to people who seek legal education, I think what might be very useful is to tap into existing networks, which does not mean that the startup won't have any added value of itself, but there are very good international existing networks. For example, here in Europe, but I'm sure there are global chapters of this as well. We have something like ELSA, that's the European Law Students Associations, and so on. And to maybe enable, for example, linking or collaboration or exchange of information, or just the opening up of each other's networks. This is one of the great advantages that we, as the generation of students that lives now and has these technical possibilities on their hands, can make use of. So this is something I would encourage to enter, get into exchange with existing networks. With the use of AI, well, it depends very much on what it is that the goal of the startup is, what it is that you are trying to achieve. Is it information about AI, or would you like to, for example, implement AI, as I understand is possible now, as part of the service that you offer online? I don't have the background on it, and I'm also not a programmer or technical expert who could help you implement this. In general, I believe that AI will play an ever-increasing role in legal education as much as in all other aspects of our lives. And it is important that students learn about it, but I think it's even more important that lecturers learn about it, because students are, when it comes to use, they are a step ahead. When it comes to awareness, including awareness of, for example, false information, or awareness of dangers, abuses, they might be a step behind. So I would very much encourage educators, universities, strategists, ministry officials to adapt their guidelines in such a way as to stay, on top of the development as much as possible. Now, with regard to your second question, it is not possible to ignore these questions at the moment, and I was very much expecting that in whatever context we speak about law in an international context today, it would come up. I must make one disclaimer. I'm not an expert in international law. I'm a comparative constitutional lawyer. Nonetheless, well, you mentioned the position that European citizens have, and I think one very important point to make here is that European citizens are an extremely diverse group. So I don't think it is possible to say European citizens have this or that opinion on the conflict. It is true that, of course, for historic reasons, out of a number of reasons that are too hard to entangle in a very short while now. European countries and Western countries more in general, including also the US, Canada, etc., have, and I think very rightfully so, expressed solidarity in the aftermath of the very atrocious terrorist attacks that are not justified by anything that have been perpetrated at the beginning of October at the hand of Hamas. On the other hand, what is now also visible in the European public, and I'm quite happy to see also in the European public sphere, in political debates, in interviews by politicians, and at the General Assembly of the United Nations, for example, is that increasingly the plight of the people who are now in Gaza and who are now being under attack by Israel, and of course the tremendous suffering that is being caused there, is not only acknowledged, but that they are also increasingly called to hold this. I am very much in favor of calling for a ceasefire, of course. It is too far and certainly not my place to try and disentangle the entire conflict in the Middle East. That I can't do. But I would caution anyone against trying to adopt a one-sided perspective of the European citizens or also the Indonesian citizens. Of course, there is, and this is very very well known and also very natural, solidarity between many Indonesian people and the Palestinian cause. There is also not a little of this in many European countries. It is an atrocious conflict. I very much hope that it can be resolved peacefully. You are asking me what is the best strategy to resolve it peacefully and quickly. If I knew that, I think I should be doing something else altogether. I simply do not know. And I do not have a strategy for this, but I think a very important thing is not to lose sight of the equality of human life on all sides. I think that's the answer I can give to this. I think we have time for one or two more questions.
Sorry?
I think we have time for one or two more questions.
Yeah, one or two. Oke. Baik, saya translasikan sebentar pertanyaan tadi. Jadi yang ditanyakan oleh Maulana ada beberapa hal tadi berkaitan mengenai AI juga sudah disampaikan. Memang AI ini perannya tidak bisa dinegasikan juga. Ke depan ini akan memiliki peran yang penting. Cuma sudah disampaikan bagaimana kita dengan baik dan bijak menggunakan pemanfaatan AI itu sebagai sumber referensi dalam ilmu pengetahuan. Dan dalam konteks yang lebih luas lagi, memang kedepannya itu dibutuhkan juga regulasi ataupun pengaturan yang baik dari otoritas yang berwenang. Nah, untuk pertanyaan yang mengenai berkembang di Timur Tengah saat ini di Middle East, Dr. Sasa sudah menyampaikan beliau bukan kapasitas sebagai ahli hukum internasional karena beliau bidang spesialisasi beliau adalah perbandingan hukum tata negara. Tapi dalam konteks ini beliau juga menyampaikan beliau dalam pilihan ini lebih baik adanya gencatan senjata sekarang dan penyelesaian secara damai. Barangkali komunitas-komunitas masyarakat di berbagai belahan dunia bisa menyuarakan hal tersebut, baik di Eropa sendiri ataupun yang di Indonesia yang menurut beliau warganya cukup sangat aktif dalam mendukung memberikan simpati terhadap apa yang terjadi di dalam konflik Israel dan Palestina. Berikut ada pertanyaan dari International Class Faculty of Law dari Universitas Bengkulu. Lanjut ke Yuki Sitompul ya habis ini. Silakan.
Thank you, Miss- Mr. Kovar. Can you hear my voice? Sorry. Okay.
Yes.
Good morning, Dr. Hart.
Good morning.
ChatGPT or any other AI is very useful for us as a student in academic. But in Indonesia, there are no regulations concerning the copyright of the product result of the ChatGPT or any other AI. What do you think about it? And compare this issue in Netherlands. How Netherlands government solve this issue? Thank you, Doctor.
Thank you very much. This is an interesting question. I think the Netherlands government hasn't solved this issue. Just as much as most other governments in the world. Well, copyright, and there are several sides to this, of course. And when students use the text generated by ChatGPT to substitute for their own. So when you get a question and you have to write an essay, and that is part of your coursework, and you use ChatGPT to write it for you, this is not in primary instance a copyright issue. It is an issue of fraud. So this is because this is a fraud attempt. Currently, I believe since the ChatGPT is upon registration and there is no prohibition from or no kind of intellectual property on the part of the provider of ChatGPT, OpenAI, to copyright whatever comes out of it. It would also be tricky to do this because the business model of OpenAI, of course, is to encourage the wider and wider use of the product to also improve its service. So I don't believe that copyright in the sense of OpenAI retaining ownership of all the text that ChatGPT and its successor programs produce is likely going to come. I don't think that this is really the primary issue. The primary issue is, how do we treat the content that ChatGPT produces when somebody either incorporates that into their own work? Will it, for example, merge with their copyright of their own work? Or if they substitute ChatGPT's product for their own work, what about the copyright that this person then has? I believe that to a large extent, in most jurisdictions, this is an unresolved issue. When it comes to students, my pleading is twofold. Be very cautious of substituting ChatGPT's product for your own work, because it can be wrong and it is cheating. However, make good use of ChatGPT, and here I don't see a copyright issue because it is the same as what other programs prior to generative AI have already been doing. You make good use of ChatGPT to improve your writing. So write a text, put it in ChatGPT and ask ChatGPT to summarize it, to shorten it, to translate it, to clean it up, to correct your mistakes. All of these are uses which there are, I don't think, any regulatory trouble with when it comes to university policy. On the side of lecturers, I would urge you learn how this works, and especially adapt the way you ask questions, because we can make this a non-issue. We can ask questions which ChatGPT will not help too much with. It's only a question of what do we assess, what do we grade? Do we grade the quality of the language? ChatGPT does it perfectly. It's not useful. Do we assess the quality of argumentation that lead up to a value judgment? ChatGPT is rubbish at it, and we will be still able to give meaningful grades. So that would be my answer to this one. Thank you very much for the question. I think I have time for maximum one more, because at 10 I need to be in another online meeting. Apologies.
Yang terakhir, pertanyaan terakhir, silakan. Tadi Yuki Sitompul. Singkat dan padat ya. Yuki. Masih ada? Tadi ada Yuki Sitompul.
Halo.
Hello.
Okay. Good morning, Dr. Hart.
Good morning, good afternoon.
My name is Vicky Stompul. I is a student in the Faculty of Law, West Sumatera Barat.
Suaranya bisa deh berjelas sedikit.
Well, let's get straight to my question. How will the development of globalization and digitalization affect legal education in various countries around the world in the 21st century? I think that's all, and thank you very much.
Thank you very much. Now, it is, of course, an extremely broad question. How will it affect? Well, it already affects everyone, everywhere, and legal education in every country. So the things that I mentioned earlier, that transactions are becoming globalized, that therefore the law itself is becoming globalized because we have norms from international systems, we have multi-level governance, we have interactions with foreign legal systems. This is something that affects legal systems and therefore also in due time legal education around the world. Now it is so that some education systems are faster, more advanced in this than others. And I think Indonesian legal education is on a very good path because this has been recognized and this is already being worked on. But you can always do more. And I think also in Europe the situation is very diverse. So you can't speak of a European system of legal education because they are all very different when it comes to the country you look at. Even between the countries I live in and work in every day, Germany and the Netherlands, they are extremely different. But it's affecting everybody, and it is certainly worthwhile from a student's perspective, from a lecturer's perspective, from a university's perspective, and from a ministry's perspective, to have policies in place to react to this and make a strategy of how to work with it rather than work against it, which will never function. Thank you very much for your kind attention.
Baik, terima kasih. Thank you, Dr. Sahar, for your great presentation today. Barangkali saya akan menyimpulkan dari perkuliahan yang diberikan pada hari ini. Yang pertama berkaitan dengan pendidikan hukum di era abad 21 di antara globalisasi dan digitalisasi ini. Yang pertama ini berkaitan dengan kebutuhan ya untuk menginkorporasikan atau mempertimbangkan digitalisasi dan globalisasi ini sebagian dari konten kurikulum di pendidikan hukum ya dalam rangka mengakomodir perkembangan zaman tersebut, sekaligus ini juga kebutuhan pasar bagi profesi-profesi hukum di abad 21. Kemudian yang kedua, digitalisasi dan globalisasi mempengaruhi cara kita dalam belajar dan juga memberikan pendidikan termasuk di bidang hukum itu sendiri. Beliau sudah sampaikan tadi apa saja yang menjadi tantangan dan peluang dalam globalisasi dan digitalisasi pendidikan hukum tersebut. Yang ketiga berkaitan dengan digitalisasi khususnya mengenai artificial intelligence. Bagaimanapun ini AI sangat memiliki peran yang besar sekali baik bagi para mahasiswa maupun para dosen dalam pekerjaan-pekerjaan yang berkaitan dengan tugas-tugas mereka di kampus. Nah, tapi tadi sudah disampaikan bahwa penggunaan artificial intelligence ini juga harus dilakukan dengan bijak dan kehati-hatian. Jadi ada nanti jangan sampai misinformasi ataupun adanya informasi yang palsu ataupun fraud di sana. Tapi gunakanlah manfaat dari AI itu sendiri seperti dalam membantu dalam penulisan ataupun translasi misalnya. Nah, itu yang barangkali menjadi simpulan diskusi maupun kuliah internasional kuliah umum internasional kita pada hari ini. Now we at the end of our meeting. So I would like to thank you to Dr. Sasa for your great lecture and presentations. And thank you for the audience for their active participation. Thank you very much. See you next month.
Thank you very much, everybody. And I hope to see as many of you as possible in person soon.
Okay, thank you.
Bye-bye. Thank you.
Bye.